Hi, my name is Brad Dixon. I'm a trial lawyer, and today I want to talk to you about the court-martial process. Now, first you have to understand there's several different kinds of court-martial. Today we're going to talk mostly about general courts-martial, which is sort of like the felony level court if we're going to compare it to a civilian system. And what that means is that if a person is convicted at a general court-martial, then they can be sentenced up to the maximum punishment for that offense, which can be greater than a year. Now, a general court-martial starts with the preferral of charges, not to be confused with referral of charges, which we'll talk about here in just a minute. Preferral of charges means that somebody in the Army has either looked at the evidence or they've investigated the case and they've determined that the evidence supports the charge against the soldier. If the person who reviews the evidence determines that there's enough evidence to support the charges, then a trial counsel, and that's the legal advisor for your command, administers an oath to that person, and they swear under oath that they've investigated it or that they've had the information made available to them and they believe that the evidence supports the charge. And then what happens is those charges are presented to the accused. And that's the same concept as a defendant in the civilian system. In the military, we call a defendant an accused. What happens is that accused commander calls him into the office, sits him down, reads the charges verbatim off of the charge sheet, and notifies him that charges have officially been preferred. From that point, that charge sheet makes its way up the chain of command all the way to what we call the General Court-Martial Convening Authority. That's normally the commanding general. Before they get there, though, those charges have to stop for just a bit at the brigade commander's level, and the brigade commander appoints what's called an Article 32 preliminary hearing. Now, that preliminary hearing is kind of like a grand jury in the civilian system, and what we're doing there is we're trying to determine, is there enough evidence for this case to go forward to trial. Now, after the preliminary hearing, the hearing officer drafts up a report and they send that up to the brigade commander, because remember, the brigade commander is the one who appointed this Article 32 preliminary hearing to begin with. The brigade commander gets the hearing report, he or she reviews it, and then he or she makes their recommendation on up to the commanding general. Now, the commanding general gets involved because the staff judge advocate, that's his legal advisor, and the top legal advisor for the installation, he takes those charges and all of the evidence and the preliminary hearing officer's report, packages it all up, and he takes it into the commanding general and gives the commanding general advice about what he should do with those charges. And the options obviously are dismiss the case or refer the charges to a trial. This is referral. Remember, preferral is when a person is charged. Referral is when the charges are sent to the trial by the CG. After referral, then the charges and the evidence is actually sent to a court, a judge, a military judge, who is a JAG officer, normally a lieutenant colonel or a colonel, and the judge will set an arraignment date. And this is your first appearance in front of the judge. At the arraignment, that's when you enter a plea of not guilty or guilty, and if it's not guilty, that's when you can start to file motions, discovery requests, and really start to investigate the case and learn what's out there and start to build your defense. Later on, after the arraignment, then normally the next thing that happens is a motions hearing. So if any motions are filed, then there's a hearing and the judge hears arguments from the prosecutor and the defense on these motions. And they can be motions to dismiss, motions to suppress evidence, motions in limine to prevent the other side from doing or saying certain things at trial. There's all sorts of different motions. After that motions hearing, the judge will issue his or her rulings, and then the parties have a better idea of what kind of evidence is going to be admitted at the trial. Now later on, when we get to the trial itself is really similar to a civilian trial. There's the voir dire process, in which we ask lots of questions of the panel members. In a military system, we call the jurors panel members. We call a jury a panel. We ask those questions and we determine who's best suited to sit on this case. Now, the major difference between a military jury or a military panel and a civilian jury are the number of votes that are required for a person to be convicted. In the civilian system in Georgia, it has to be a unanimous verdict. All 12 members have to find beyond a reasonable doubt that the defendant is guilty. On a military panel, the panel, which has to have at least 8 members for a general court-martial, 3/4 of them have to vote that the person is guilty beyond a reasonable doubt in order for a person to be convicted. From a defense perspective, what that means is, instead of convincing 12 people that a person is not guilty in a civilian system, in a military system, that means that you only have to convince 3 people on the entire panel. Because remember, the government has to convince 3/4 of the panel that the person is guilty beyond a reasonable doubt. If you have questions, don't hesitate to reach out.